Hello, I'm Lee Dunstan. Welcome to the Academics. This week, two of our regulars, Dr. Nancy Love and Dr. Michael Wade, are marked absent, which leaves us with me and the other attorney on our panel, Dr. Paul Gates. So if you can stand to be in the company of two lawyers for 26 minutes, we thought we might chat about the new season of the Supreme Court, which is just beginning, and perhaps some other interesting legal matters. So here we go. So Paul, the Supreme Court is once again going to be dealing with the death penalty and whether the death penalty in all of its ramifications is constitutional. Can you give us a little bit of background and kind of where they find themselves in this session of the Supreme Court?
Well, I think what makes this term interesting as far as the death penalty goes is that last term, in the Glossip case, Justice Ginsburg and Sotomayor signaled that they might be ready to make a declaration that the death penalty is a violation of the Eighth Amendment.
The Eighth Amendment being that amendment that says that it is a violation of the Constitution to engage in cruel and unusual punishment.
Exactly. Right.
Were they focusing on cruel, or were they focusing on unusual, or both?
I think mostly on cruel. I think that's where the better argument lies these days. The unusual has been trotted out. Usually you're talking in that case foreign law, and the court's trying to stay away from that, I think. That will turn off too many members of the right wing of the court if you push that too hard.
That may be true, but Breyer just published a book where he's talking about how the court in a globalized world must be cognizant of the law that exists throughout the world so that it at least can be informed about how the United States and its law finds itself in this larger context. So he's standing up. Justice Breyer is standing up for the notion that we've got to at least be informed about foreign law. And if that's true, then it would be also true, would it not, that the United States is the only developed country currently that has the death penalty.
That's exactly right.
And I guess that's unusual.
Well, you would have to accept that foreign law argument and the court, I don't think, is going to go there. There's too much pushback from the right wing that will not.
Are you suggesting that the court is political?
I think I am, Lee.
Oh my God! All right. So help us out here. So where is the court going to move in this session, in your opinion, on this death penalty question?
Well, it's looking like they might be leaning toward declaring it unconstitutional. I mean, the death penalty has not really been at the court for a while, and I mean, the real arguments that are being tested again come from the 70s, and when in the Furman v. Georgia in 1972, that's where Justice Brennan decided that he was no longer, as he put it, going to tinker with the machinery of death. And he had decided once and for all at that point that the death penalty was unconstitutional. And that led to a moratorium on the application of the death penalty for 4 years until it was overturned and went back to being an active penalty in the Gregg v. Georgia case, 1976.
So we've got the cruel and unusual argument. We have the unequal application. How does the unequal application argument work?
Well, usually that's brought.
In other words, so our audience understands, we're talking about the imposition of the death penalty, and that death penalty has, when it is imposed, is unequally applied to different persons and different groups of persons.
And the groups of persons involved it's a racial categorization. And that is always, and the statistics bear that out, that has always been the case, but has not influenced the court that much.
So if you're Justice Scalia, I think you say in conference, ladies and gentlemen, being when the justices sit down to discuss these cases, if you're Justice Scalia, you say, Well, I'm not sure that it matters so much if it's an unequal or inappropriate application. If the person is a first-degree murderer, he may, in fact, deserve the death penalty pursuant to the process of law.
Well, it's easy to fall back on the facts of the case, as perceived by the justice, to justify a vote one way or the other, and thereby support the unequal application. Sure.
Yeah. Now my question goes to another aspect of attacking the death penalty, which is this notion, which apparently is supported by substantial statistical evidence, including a number of people who have been exonerated, that 1 in 50 to 1 in 100 people convicted of murder and sentenced to death are in fact not guilty of the crime for which they are being asked to give up their life.
Well, to buy that argument, there's the old saying that, better than for one guilty man to go free than one to be put to death wrongly. And that is a trade-off that apparently the court is decided that there's a stronger argument for imposing the death penalty than there is for exonerating somebody who may in fact be guilty.
Let's play a game here, Paul, if you will. So we're on the Supreme Court. You are on the Supreme Court, and we're in conference, and you are arguing to maintain the death penalty, and I bring up the issue of it is obvious that some people, innocent people, have been put to death. How can we allow this to go on until we are completely satisfied that all the processes that we have in our system are such that we're not going to be putting innocent people to death?
Well, I think
what is your answer in conference?
I'd have to argue that you're never going to have a perfect process, and that you do your best with due process.
Well, if you're never going to have a perfect process, then you shouldn't be putting people to death.
Well, but
I mean, that's the one place, it seems to me, where you shouldn't be proceeding on the basis of, perfect is the
enemy of the good.
The enemy of the good.
Sure.
And it's awfully good to be putting these bad folks to death.
That's right. So we settle for good enough.
We settle for good enough.
Is the argument I think that you're just...
And Justice Scalia, if your cousin happens to be one of these people, you may even pull the lever yourself. We got to be careful here. It doesn't make any sense to me.
No, it doesn't.
And I'm not trying to convince you, because I think you'd be a heck of a good Supreme Court justice. Any other thoughts on this death penalty situation? Could they go off on another? So we've got cruel and unusual punishment, we've got unequal application of the penalty, and we have the clear evidence that there have been innocent people put to death.
I think those are the only questions. I think that identifies the 4 questions that justify questioning the methods and questioning the imposition.
What about this notion that we somehow demonstrate that we are a weak, spineless society, and that we don't have the guts that Vladimir Putin has if we can't just electrocute somebody or make sure that we put them on a gurney and make sure they're gone?
Well, I don't think that's a legal argument.
No, it's kind of a cultural argument.
Yes, absolutely. It's a return to medievalism to support that.
I'm curious, do you think that part of the American cultural frame is that issue? That is, we are not going to be weenies.
Sure.
We're going to be tough.
Yeah,
and if an innocent person has to go down in this process, we're going to maintain our toughness.
Right, because retributive justice is the foundation of our criminal system. We've got to get even.
Okay. Ladies and gentlemen, I hope this has helped you understand a little bit of some of the issues that the court faces. We've done some smiling and laughing here. This is not a funny matter. It is a life and death matter, but we hope that you have gotten a little bit of a sense of what's going on inside the Supreme Court of the United States, where most of these issues go down 5-4. How about diversity and affirmative action, this Fisher versus the University of Texas case, which I guess is in this term and will be decided. So once again, this court is going to be looking at the concept of affirmative action in higher education and whether an admissions committee sitting to admit people into a university is going to be able to take into consideration race and other socioeconomic issues.
Yeah, this is not Abby Fisher's first trip to the Supreme Court. This case was heard a couple of years ago, and the court remanded the case to the district court to have them examine whether perhaps there had been too much deference shown to the university selection committee. And went back to the district court. District court said, no, we were fine. Everything we did was right. And now that's coming back to for final judgment.
What is the history of this? Like, take us back to 1978 when Justice Lewis Powell, who is now long deceased, wrote one of his most famous opinions called the Bakke case.
Yeah, the Bakke versus the Regions of California. It was a medical school applicant who was basically arguing, he was a middle-aged fellow.
And he was a white man.
And he was, I think, using both of those characteristics in his argument, that he was denied application to medical school and others not as qualified were admitted. And the Supreme Court, in Powell's famous opinion, held that differential treatment for good social purposes was allowed under the Constitution.
So let's talk about that. I want to be sure that our audience understands. So Lewis Powell, who was appointed by Richard Nixon and was a Republican all of his life and considered a conservative, wrote an opinion in the Bakke case that basically says this notion of diversity inside an educational institution when young people's minds are being formed is a very valid educational goal and one to be promoted.
Right.
And so Lewis Powell says in the Bakke case, if admissions committees in universities look at race and consider diversity inside their student body as a good thing, that is appropriate.
Sure, that's in the interest of creating a more heterogeneous student body with different cultural experiences.
Which is more like our country.
Exactly, looks like the country.
So if you're going to be educated, you better be educated in an atmosphere that looks like our country,
right,
which is becoming more and more diverse every day.
Right, the atmosphere you will be graduating into is more diverse, and therefore this is good preparation.
So let's be clear, that's Lewis Powell in 1978, okay? So almost 50 years ago, Lewis Powell has these ideas, and ever since then, those ideas enunciated in Bakke have been chipped away at. Is that right?
Yes, that's right. There's been a number of cases over the years. I mean, there's a lot of cases out of the University of Michigan involving law students and undergraduates. And yeah, that attitude has not fared well in cases subsequent.
Why?
You don't have the same court. This is a different court than we had in 1978.
Right. I'm curious, so let's see if we can put ourselves on a mythical admissions committee. What do you think we can now look at? I know the court has said no quotas, absolutely no quotas. What can we look at to avail ourselves of some of the remaining guts of Lewis Powell's Bakke decision? In other words, Powell saying diversity is really a good idea, really important, and arguably even more important now that our country is even more diverse.
Right. Well, one of the things that has had some success, I think, is an approach where admission would be granted, and this is to public universities, of course, admission would be granted to a certain top percentage of each graduating class. and that would apply statewide, and of course that would encompass, hopefully, minority districts, school districts.
So say, for instance, in North Carolina, if you say the top 10%
Right.
are going to be granted admission into the North Carolina university system,
Right.
that would include the top 10% in a minority school
Right.
that might not have, we don't know, but might not have as high a degree of achievement as a suburban white school.
Right? It would.
And so then the suburban white school person comes into the court and says, hold it, that whole idea is improper because it is discriminating against me who has more qualification, higher SATs, better blah, blah, blah. I am entitled to be, rather than this person of color who doesn't have the same qualifications to be in the University of North Carolina.
Well, that's the argument, but the percentage argument is that everybody gets an equal shot from a particular high school, and let the chips fall where they may. And again, we're reflecting the population, the demographic characteristics of your entire state.
Do you think that's going to hold? Because that's the way this court has been moving over the last 15 years. It seems as though they're really trying to make sure that all such considerations of admissions committees may be ruled unconstitutional.
Right.
Do you think we can hold here?
I don't know if it's going to hold. I think the progression is going to continue the way we're headed, and this court is not. I don't have a great deal of hope for that attitude on this court.
So on this issue, you think this court's going to continue to chip?
I do. Yeah.
And so the argument that young people, so we're in conference again, we're in this mythical conference, and Justice Ginsburg says to Justice Scalia, who she is very good friends, they're very good friends, they prepare dinner for each other, they socialize all the time, and she says, don't you understand, Nino, that the country, these young people need to be educated in a diverse atmosphere? To which Nino says, Scalia says, I expect them to be qualified. Otherwise, they don't get in.
Right.
It's just that simple. Mm-hmm. Ruth.
I think that's it. Why do I always have to play Scalia?
Well, I don't want to play Scalia. All right. But he is fun.
Yes, and he's a good writer.
Yeah, yeah. He's not a very consistent person, in my opinion.
No.
Consistency is the hobgoblin
Of little minds.
Of little minds, yes.
That's right.
So can we focus a little bit now on the freedom of religion issues and Burwell? Help us with this case. Give us a little bit of background of this case.
Well, this is the objection to filling out a form for an exemption to the Affordable Care Act. This is a Catholic religious group, the Little Sisters of the Poor, are objecting to the requirement under the Religious Freedom Act that they fill out a form to exempt themselves from the birth control requirements as presented by the Obamacare.
So Obamacare is not saying, sisters, you have to provide birth control. It's not saying that.
No.
But Obamacare is saying, in order for you to not be required under Obamacare to do this, you need to fill out this application form that allows us to then go ahead and make contributions to the insurance companies, and the insurance companies will then cover the women that are in your employ as to reproductive issues.
Right. And I think what they're simply saying...
What in the world is going on?
Yeah, I think they're saying that this is a burden that they should not have to bear.
I shouldn't have to fill out the application?
Right. Under the Religious Freedom Act, we should be exempt from
I
it.
was taught by the sisters, and they're very energetic. They used to beat me about the head and shoulders routinely.
Yeah, I imagine so.
They're energetic.
Yeah.
They can fill out the application.
They answer to a higher authority
I see.
than the Congress.
So theoretically, are the sisters really saying that in some way their religious freedom is being impinged by having to?
Yes,
So
unduly burdened by that form.
So there is a burden associated with their religious beliefs to just fill out the form.
Right. They should not have to do something extra in order to exercise their religious freedoms.
What if
under the law.
the Secretary of Health and Human Services were to say, all I need is a phone call from a big shot sister, and that's all I need? Would that be too much?
By this line of thinking, the answer would be yes. Sure.
Right.
It's something
Right.
that they would have to do that nobody
Right.
else has to do.
I guess my question on something like this is, what is the political issue motivating the little sisters? Because it almost seems political as opposed to religious.
Well, it does. They're relying on not just the First Amendment guarantee, free exercise and so forth, but they're falling back on a congressional statute, the Religious Freedom Act.
So I want
so
to
that's
ask you.
political.
So there's a statute upon which they're basing
Yes.
their argument.
That's right.
And my question is, when you have a statute that seems to enhance the power of the freedom of religion clause of the First Amendment, what takes precedence?
The First Amendment should take precedence.
Okay.
I'm not sure it does, but it should.
Okay. Any other cases that we should be talking about?
Oh, compulsory union dues, maybe?
Compulsory union dues.
I bring this up because this is revisiting an old case which said that compulsory union dues was constitutional. That was the Abood case from, I think, Detroit in the late 70s, 1977. And now this has come back again from a California teachers group that is objecting to have to pay union dues to support, the theory is going, support issues and positions that they don't agree with. Mm-hmm. And this would be, to accept their argument, would be to overturn a case from just 40 years ago.
And what was the, if you recall, what was the underlying foundational reason the court said it is okay to require people who are in a union to pay their dues?
I think it was because the general support for the argument of compulsory dues is that everybody benefits. And
you can't be a free rider.
Right. You're right. Because people would do that if it were allowed. So everybody pays. Everybody benefits equally. And that even though you might object to some positions that are being supported with your money, other people are going to be funding positions that you agree with.
And we think that there's a chance that this court, in a 5-4 decision, may finally rip the foundation out from under unions.
Yeah, mm-hmm. Sure. That would put them. It's the right to work frame of mind that I think they might be headed for.
Okay. Any other cases that we think are? If we don't have any other cases that I'm curious about what views you might have on John Boehner and on Kevin McCarthy, and what everybody's talking about what this means for the Republican Party. Let me make an observation. The Republican Party appears to be, to some extent, riven by its inability to come together. And I think this is a matter of fairly simple math that is going to be very difficult to overcome. The math I'm talking about is, in the 2010 election, the Republicans had such a huge win throughout the country, they were able to gerrymander so many congressional districts that what has happened is that they have these deep red districts, and make no mistake, there's some deep blue districts, but the deep red districts have constituencies that say no compromise. And if you dare compromise, if you compromise on anything, we will challenge you in the primary. And so, you have a group of people in this, quote, Freedom Caucus who hate compromise, who don't want to compromise, who would like to shut the government down. So how do we solve this?
By changing the redistricting rules. And it just so happens that actually there is a redistricting case before the court. I hadn't thought of that right until you started describing this dilemma. But yeah, it's a case coming from Texas where this kind of thing is commonplace, I think. And their legislative rules as far as creating these districts has put them in this position that you might do well in the primaries, get somebody who holds the anti-tax view and all those other kinds of positions, but then in the general election, the very same thing might work against you.
So what does the case seem to want to deal with?
The rules about how you redistrict, who you count as for purposes of creating a district, whether you count all population or all voting population.
Okay. But would you agree with me that the math in this area is really kind of against any compromise at the moment?
Oh yeah.
Right.
Yes, absolutely.
Okay, well, I think we've kind of gotten through our legal stuff, and we talked a little bit about politics and the Republican Party. Ladies and gentlemen, thank you for joining us on the Academics. We'd like to hear from you. Please contact us with your questions and comments at watchapptv.com. Until next time, I'm Lee Dunstan. Thanks for watching.